Going. Thanks for participating in this session focused on diversifying IP education for national competitiveness. The who, the what, and the how. Intellectual property education has traditionally been taught as a specialty area of the law. However, as national competitiveness in the knowledge economy relies heavily on the creation, management, and commercialization of IP, and the knowledge of IP in society across, so the IP in society must also increase across multiple actors. This session will take a critical look at the need to diversify IP education, including who needs to know about IP, what they need to know, and how it should be taught based on a broad set of people with different experiences within the educational field. So I'd like to start by introducing our great group today. My co-chair for this will be Paul Michel. He's the former chief judge for the Court of Appeals for the Federal Circuit. We have Jelani, Odlum, the program manager for the Michelson Institute for Intellectual Property. We have Dave Kappos, who's currently partner at Cravath, Swaine, and more. We have Bruce Berman, the CEO of Brody, Berman Associates and the chairman of the Center for Intellectual Property Understanding. And we have Demi Ibrahim, who's the medical device research intern at RPX Corporation and a recent graduate of UC Berkeley, where she participated in one of our courses. And it's great to see her again and see everyone again. So what we thought we would do today would go around and let everyone give a little bit of their experience on the who, the what, and the how when it comes to IP education. And then we would have a little bit of a roundtable discussion amongst the participants. But we would like rather soon to allow the audience to enter in with questions and comments. So if you have any questions or comments after everyone has had about 5 minutes each to discuss, then please raise your hand and we can call on you. You can participate. It's fine if you want to leave your video on, but it would be good if everyone put their microphone on mute when you're not speaking. All right, does that sound reasonable?
Mm-hmm.
Reasonable ground rules? All right. So let's start with Jelani. Kick us off.
Okay, sounds good. Thanks, Bo. Hello, everyone. Good morning, good afternoon, good evening, depending on where you are. My name is Jelani Odlum. I'm program manager at the Michelson Institute for Intellectual Property, and we are a nonprofit initiative of the Michelson 20mm Foundation based in Los Angeles. And our work is in closing the IP education gap for budding entrepreneurs and inventors. Our founder is a prolific inventor, Dr. Gary Michelson. For those of you who might not be familiar with his story, Dr. Michelson is one of the most prolific medical inventors of our time. He holds over 950 patents worldwide for his medical innovations, particularly in the field of orthopedic spinal surgery, and is a self-made billionaire. And today he's actually a philanthropist. He's a signer of the Giving Pledge, which is sort of a pledge of the world's sort of wealthiest individuals to give away at least half of their wealth during their lifetime. And so this is one of Dr. Michelson's several foundations, but our work is in really building curriculum and resources and communities to help spread IP education and awareness. We do this primarily at the undergraduate level, but also moving into the K-12 space more over the past year or so. And yes, our curriculum and resources are just really focused on the fundamentals of intellectual property. Everything is built pretty modularly so that we can incorporate it and integrate it into a variety of different programming and curriculum. And yeah, we're really excited about the partnerships that we've built and some of the reach that we've seen. This year alone, we've seen over 40,000 new subscribers to our materials and resources and communities. So just really grateful to be in this space and excited to continue the work. So that's my intro, and I think I will stop there. Bo, you are on mute.
Can you hear me now?
Yes.
There's a delay, sorry. It's a delay. It's probably good. My wife probably would like me to have a delay mechanism. Bruce, go ahead. Thanks a lot, Jelani. Appreciate that.
Sure, sure. I'm unmuted now. Sure. Bruce Berman. I wear a couple of hats. I'm here really for the Center for Intellectual Property Understanding, which is a nonprofit, independent nonprofit that I founded with Marshall Phelps and a couple of other folks in 2016. Our focus is IP awareness, education somewhat, but also gathering the incredible good materials out there that people are often unaware of. There are materials at WIPO, US IPO, UK IPO, USPTO that are wonderful for helping various audiences understand IP, but people don't know about them. And that's part of our role, is to help popularize or publicize what's out there. We also do create reports. We've held 3 IP awareness summits, one at Berkeley in March. We just squeezed it in pre-COVID, or actually just before COVID really took off. And we have reports, awareness briefings. We did two or three briefings in Washington, D.C. with the Global Innovation Policy Center. And we are really focused on stakeholders, and I will talk a little bit about stakeholders later, but who are the IP stakeholders? And there's a lot of dispute as to who really has a vested interest in IP. There are direct interests like investors and creators, but there are also more indirect stakeholders as well. My day job, if you will, is Brody, Berman Associates, which since 1988 has been helping IP holders, creators, plaintiffs and defendants in cases, and IP service providers convey what they do, their resources. We help to explain assets. We've worked with MPEs, public and private, and we've worked with defendants in litigation as well, and also transactions. We're the communications people, and that's what led me to CIPU, is the involvement in explaining what IP is to various audiences, especially those who who are most affected by them, which is, many people. I think that's a good intro. Bo?
All right, thank you. Dave, would you like to go next?
Yeah, sure, Bo. Well, good morning, good afternoon, and good evening to everyone. Dave Kappos here. So, having been in lots of roles over a long career that have involved IP education, I've become over time a big believer in its importance, but also in the importance of diversity in education, the focus of this panel, and also the daunting nature of the challenge. So, Bruce has mentioned his organization, which is dedicated to IP education. Jelani's mentioned her organization, which is dedicated to IP education. There's another organization that I'll mention right now called the IPO, Intellectual Property Owners Education Foundation. Judge Michel and I sit on their board, and there may be other people on this call who do as well, or at least are aware of that organization. A third organization that is entirely dedicated, you might guess from its name, to IP education. Of course, the United States Patent and Trademark Office has an entire function that's funded and dedicated to IP education, and the list goes on and on and on. But yet, you see prominent op-eds, let's say this morning, how about that? In the New York Times, kind of a prominent newspaper, that call for the abrogation of intellectual property for a worthy cause, to be sure, to make sure that a COVID vaccine is distributed widely, especially in the developing world. But of course, the problem with that, as important as it is to distribute a COVID vaccine in the developing world and everywhere else, is that IP has absolutely nothing to do with that problem. That problem is entirely a function of the lack of refrigeration in developing countries. It's entirely a function of the lack of distribution channels in developing countries. And it's entirely a function of corruption in developing countries that we know historically ensures that important medicines don't go to the people who need them. So we see, as recently as this morning, the difficulty, the challenge, the importance of IP education and of the diversity of IP education in terms of who needs to be educated and in what areas people need to be educated. Even just this morning, the New York Times article would, if you think about it, would lead you to believe that the news media, including at the highest levels, needs to be educated. Policymakers, right, the target of that article, need to be educated. That's state, local, federal government officials. Medical professionals need to be educated. They're clearly a target for that article. And of course, the general public needs to be educated. They're clearly the people who read articles like that. And we haven't even talked about children. Bruce and Jelani referred to as being huge focal points of their educational efforts, which are also hugely important. And I should expand from children to students of all ages, whether they're kids in preschool or elementary school, all the way up through college and postgraduate. So indeed, Bo, I'm looking forward to the panel discussion, and I just find myself reflecting that the challenge is daunting. You don't have to go back any further than this morning to realize that. Thanks.
Thanks a lot, Dave. Demi, would you like to share your thoughts?
Yeah, I'll introduce myself really quick. Hi, everyone. I am Demi. And as Bo said, I'm a recent UC Berkeley graduate. And but a little background about myself. I did undergrad at University of Illinois, Chicago in bioengineering. And my undergrad experience was really technical, very math and science heavy. Didn't really do anything related to patents or IP education at all whatsoever. And so I didn't know much about IP strategy or anything related to IP until grad school. And even when I chose my capstone, which was, I ended up working with Bo and Matt for my capstone, the way it was brought to me was like an entrepreneurship type of capstone type of project, something that can teach you how to take a product and commercialize it and market it and, and how you can kind of get it out to the public. And so that was what I was more interested in. I wanted to see how someone who was trained, I guess you could say, into like creating medical devices or creating therapeutics, how can I go from a creation to actual like products I can sell to people? And so that's why I chose that capstone. And that's how I got introduced into IP strategy and things like that. And I never would have thought of going into this space at all if it wasn't for this capstone and working with Bo and Matt. And so I definitely think for just trying to get people interested into IP, it's definitely the way it is broadcasted. It's the way it's marketed to the general audience. Because I feel like a lot of people who, I mean, at least for me before, when I thought of IP or patents, I just thought of like lawyers and a lot of writing papers or reading papers and stuff that I didn't really want to get into. And so I definitely think if it's just marketed in a different way, it can be something that's appealing to just the general audience, and they might be more willing to educate themselves in this sphere, because I think it's very important for everyone. Just as Dave was saying, it doesn't really matter your background. I think IP strategy, even if you just have a broad understanding of it, is still really important.
Thanks a lot, Demi. I have some, I think, current and former students on the line with us today, so maybe they can share their experience as well. I think they have the same thing. They it's like how do I say? I trick people into liking IP.
Right, that's exactly what happened.
Exactly,
Bo
yeah.
and Matt tricked me.
Paul, would you like to share some thoughts with us?
Well, of course, every audience that has been identified by the prior speakers is important. There's no question about it, and none can safely be marginalized or ignored. At the same time, in my view, not every audience is of equal potential impact. To take the most obvious example, young school children are not going to be setting policy at any governmental level, but they're still important. Secondly, the whole circumstance of IP rights, IP policy, IP remedies exists now in a different framework than it did, let's say, back in 1952, when there was a major revision of the patent statute in the United States that particularly focused on the innovation of Section 103 to clarify and rationalize and improve the law that had previously been existed in Supreme Court cases with some very vague dicta that didn't really make any sense, talking about synergy and flash of genius as requirements for patentability without reference to specific prior art and rigorous analysis. So 1952, the policymakers, particularly the U.S. Congress, basically delegated, you could say, the policy-making lead to a handful of patent law experts, including my late former colleague, Judge Giles Sutherland Rich. He and the Patent Office's brilliant Patrick Federico and several others basically refined the pre-1952 Patent Act, and with very little debate or controversy and almost no lobbying wars at all, the Congress passed it, essentially as proposed by the experts. So that was then. So now we're in the opposite circumstance. It's not any longer something where experts have the lead or even can sometimes have a voice that can be heard, because it has become highly politicized. It has become the subject of propaganda wars by very well-funded, well-organized groups, industries, factions, and entities with enormously talented people. And those people in turn draw on the expertise of celebrated PR firms and lobby firms and law firms and other actors to influence public perceptions and policymaker debates about patents. So the current circumstance couldn't be more different than 1952. And some of this, what I'm calling propaganda wars, occurs very much in the open. You see full-page ads in major daily newspapers over the recent decade or so that led to the passage of the American Invents Act in Washington, D.C.'s National Airport, for example. There were enormous ads, so everybody getting off an airplane was being told about patent trolls and how they were allegedly ruining commerce and technology in America. So that's the public part of the propaganda war, but there's also a secret or private part, reminds one of spy novels almost, because every day self-interested people hired by self-interested entities scurry around Capitol Hill talking to well-positioned staffers and the members for whom they work. So that's the private part. So educational efforts of the sort that have been referred to, described, or alluded to by prior speakers, in my view, are all very important, all very worthwhile. But in terms of the public debate, it necessarily focuses on the national level because patent law is national statutory law, and so the states and local governmental authorities have very little to say about it, not nothing, but comparatively little. And finally, because the courts, in my personal opinion, have made such a mess of eligibility law, obviousness law, written description law, injunction law, that the system is not functioning in a healthy, effective, efficient manner for the interests of economic growth, job creation, global competitiveness, national security, you name it. So the Congress is particularly important because the courts have fouled it up, in my opinion, and that means it can't be rescued by the Patent Office because they're subordinate to the courts, particularly the Supreme Court and the Federal Circuit. So by process of elimination, the legislative branch is the only actor that can provide the necessary adjustments and rebalancing of patent law. And so it's particularly important, and it's a very daunting particular audience that I spend a lot of time personally working on, as do others, particularly David Kappos. So those are some of the contextual realities that any educational effort aimed at any audience has to contend with. And then finally, on top of all that, there's the sort of cultural slide, I'll call it, in the United States, perhaps other countries too, but I'm more familiar with the United States, whereby many people, particularly younger generations, think just about everything should be free, and therefore patents and copyrights and trade secrets and the rest are bad things because they add costs, which of course they do. They're actually meant to add costs so that investments can be recouped and innovative entities can prosper. But there's a cultural slide toward saying that all things that increase prices or have any aspect of exclusivity are inherently evil. So that's yet another downdraft faced by educational efforts. So it's a daunting milieu to operate in, and all the better that such a talented group of people as are part of this call and conference that Bo Heiden has usefully initiated, and particularly the fellow panel members, all of their individual and collective talents and much more will be needed if we're going to get this right. I'll leave it there. Thanks, Bo.
Great, thanks, Paul. You hit on a number of issues that we're going to come back to. I thought maybe I could describe a little bit of my experience from working in IP education for the last 20 years or so, and try to frame a few of the thinking that we do, and just give some of the ideas, and then we can get into the round table. I was thinking a little bit about the question, thinking about the question that we posed to ourselves here for this seminar, for this workshop. Who are the different types of people have I been teaching over the years? And so, like Demi and others on the line now, I've been teaching master's students from multiple disciplines. So I've taught master's students from engineering, from law, from business, from biomedicine, and from design. And what is it that we try to teach them? So the main idea is that if you're going to focus if you're going to work in a knowledge economy, and yeah, we maybe need to define that. But if we tend to say knowledge-based business is built on intangible or intellectual assets and property, and that the control of these intellectual assets is a key driver of value, whether you're trying to create exclusivity around your resources or your assets, or whether you're trying to trade with them and collaborate with them. So one of the things I try to do with master's students is try to get them to kind of look beneath the surface. I think this is one of the issues that we probably all struggle with, is that intellectual property is a bit ubiquitous, in the sense that, as Paul said, and Bruce, I think it may be in the media, people are not liking it, or young people have a cultural inclination one way or another. So if you experience it, maybe you experience it in a negative way, but you never really understand the power of what it's doing that you don't see. So you hear these little bits of negative things, but you don't understand that, like, the whole system is based on intellectual assets and property. So it's the most important thing is to get that feeling to the students that, well, there isn't anything that you do that's not going to be related to this. And that, especially on a level of, say, intangible assets or knowledge, technology on that level, right? And then we can think about how we want to control it. So we try to create this toolbox that will help them to see, you put on these goggles, right? And you can see the intellectual assets and IP issues in all business contexts. So, and of course, you want to do it from a value perspective as much as possible, not just identifying patentable inventions, but trying to understand what does that mean from a value perspective to link these two together. So we try to separate a little bit of the idea of the means of control, which is often what we talk about when we talk about intellectual property, patents, trade secrets, trademark rights, copyrights, etc. We try to separate that discussion a bit from what value do intangible resources, what valuable intangible resources do you have that need to be controlled? So we have technology or technical inventions that need to be controlled. How are we going to control them? We have brand elements that need to be controlled. Do we have designs? Do we have data? Do we have content? What are these things that are valuable, that are intangible? And then what are the ways that we could control them? And by breaking it down on this level, we hope that the people that go into business, wherever they go, will start to see intellectual assets and potential intellectual property everywhere and see this as a way to create value. The how a bit is we like to teach IP as a key component in all our innovation entrepreneurship courses. So we create programs on innovation entrepreneurship to trick people like Demi into understanding that intellectual property is important. And we don't, I'm pretty sure Demi will tell us, we'll ask her later, but if we would have called the course intellectual property too heavily, she might not have taken it. But when we explain to her that is intellectual asset and property thinking is just part of the toolbox of actually accomplishing in a good way innovation in entrepreneurship, then of course you're not going to say, no, I don't want to use that, because that's a tool in the toolbox. You need to have it. So we prefer to teach it as a red thread through all the processes. And of course, we're lucky in Sweden to be able to run the whole master's program, so we can do that. We also like to teach it through action-based pedagogy. So with real innovation projects, and then Demi got to work on a real project. So she learned about IP in trying to understand it in the context of a real technology commercialization setting. So it wasn't just book knowledge, it was applied as quickly as possible. And then of course, we would like people to be together interdisciplinarily. We don't want to teach law and then engineering and then business, and we don't want to teach to lawyers and then design people and then engineers. We want everyone in the class to learn about business models, which has a mixture of everything in it with a group of people. So it's diverse in the people and diverse in the message, where IP is always woven into everything. There isn't a course that we don't teach that doesn't have IP issues in it, because there's relatively nothing going on in the business world that doesn't have IP issues in it. So if you teach it just in one place, then people think, okay, I've taken that course, that's over there. But it has to be woven into everything. When we teach PhD students and researchers, the main focus there is to try to get the researchers to understand the importance of IP in the utilization of research in society. And we use the word utilization. It's a better word. Commercialization can freak some people out. Certainly intellectual property tends to make them a little nervous as well, for some researchers, not all. But this idea that we're here to help your research become utilized in society, no one's against that. Everyone's for that. And once they understand that in order to do that, they may need to patent, and then they may need to commercialize, because that's the best way to get this medicine out into society. Then you can see that actually patenting is unethical. It's more ethical to patent than to publish. Of course, you can patent and publish. But in some cases, if you didn't patent, you would be destroying the potential to utilize things out in society. So we often talk with researchers about, we try to link the role of IP and utilization to their specific research fields, and we talk about IP and utilization as an ethical issue in the core of what they do. Last thing quickly is when we teach business and IP professionals. Typically they're separate, because the same with Demi, if I send a mail out to companies and talk about a course on the business of IP, I'm going to get people that have patents and IP in their title coming to that course. I think I've told people before, I created a course once called Advanced Innovation Management, and I got all these other people to come to it, and I taught the exact same thing that I taught in my Business of IP course. And they liked it, just like Demi. She didn't know that she liked it because she didn't know what she didn't know, right? So, and this is the same for all of us. We all have this preconceived notions and difficult to choose ahead of time. So what do you think? Do you think teaching IP professionals business is easier, or do you think teaching business to IP professionals is easier? It's interesting. We'll get back to that in a second. So so for business people, we tend to try to show them that IP is a tool that can create more value. And we try to do it in their terminology, which is profit and risk. So most business people don't know about IP. And once they understand they can create more value, they're in, because they're not picky when it comes to tools to create more value. They're pretty easy on that. At least they know what they don't know now, and they can get help, but they know that this could be useful. For IP people, when we teach them, the goal is to try to create a different mindset, because people, IP professionals, are so operational, and it's such a technical and difficult craft to be a patent attorney, for example. The goal is to lift their heads a bit to see the forest through the trees and to create a perspective on business value. So we always ask, every time I would ask somebody, what are you doing? I would say, so what? Why are you doing that? You have like a little CEO on your shoulder every time you decide to create another patent, or an opposition saying, so what? Why should I care about this? This sounds like a cost to me. Why? It sounds expensive. Why am I doing it? So this type of mindset and thinking is a little bit of the way that we push them in that regard. So that's a little bit of my introduction, but maybe I can end here with a question. Do you think it's easier to teach IP people business, or business people IP? I might have answered it already a little bit. And what experience have you had? Have any of you had in these different types of groups?
I'd say IP people business. I think it's, business schools, and we're actually doing a report on this as we speak. I have someone working on it. Business schools generally don't teach IP. And people like Marshall Phelps have said they've taught at Cornell and Fuqua at Duke, and he's taught in Europe, I think, with UBO and other places. And IP is generally not on the curriculum for business folks, but they can understand it when they want to, when they're motivated. If they see a value, if they see M&A, if they see risk, then it becomes interesting. But typically, it's not something they need to deal with. They have lawyers for that. At least they think they do. And that's the danger.
I mean, one of the things that I always try to talk to business people about is that you can hand over all the operational and the technical tasks to IP professionals, but you can't outsource strategy. And IP strategy is part of business strategy. Mm-hmm. It's not something separate. It's part of it. So you need to know. And my feeling is that if business people knew what IP could do for them, they would push the IP people to become more business focused. I don't know whether you have experience with that. Anyone on the panel with those activities? Dave?
So I would like to comment on a couple of things. I've been in this business since 1962. I started my career as a patent examiner at the U.S. Patent Office. I've had the pleasure of working with many of you attending this today in the course of my career. It's been my pleasure to work with you. I want to thank Bo and my son, Matt, and I know Bruce, Berman, and some of the other people that have been involved in setting up this effort at the University of California at Berkeley. I think it's a tremendous step in the right direction here in the U.S. I got 3 degrees separately, electrical engineering, law, and MBA, and that transpired over a period of about 12 years. So the kind of program you're talking about would have shortened that time, although I loved being a student.
You're still paying
And
off the loans, aren't you? Or
what's that?
still paying off the loans, aren't you?
Well, no, I'm not worried about that, but I did. By the way, I got into the business because the dean of my engineering school at Washington University in St. Louis, in addition to being dean of the engineering school, was also a patent lawyer that testified as an expert witness in patent litigation. And he used to get students that were graduating every year from the engineering school. He spent about 2 hours with me to tell me little about patent law. And as a result of that conversation, I ended up going to work at the patent office. During my career, I've headed up patent departments, or IP departments, I should say, for 5 Fortune 500 companies that included Apple, Medtronic, National Semiconductor, Data General, and Bally, and then started 2 software patent analytics and service companies. The first one was Origin Systems in 1993. It was sold in 2002. And then my son Matt and I, who I got interested in the business, started IP Checkups as another patent analytics software and services company in 2004, and he's been at it ever since. Before that, he was a professional musician for 12 years. So at any rate, I have to come back to some of the things that the judge talked about earlier, Michel. And I've known and worked on a group that he formed a number of years ago to help improve the IP regime in the country. And I do have to say that the Supreme Court really should not be allowed to hear patent cases when you consider that none of the justices have any experience in patents or technology, and their clerks are just a year out of law school. So I don't know why in the world we let them hear any kind of things like patent cases. The reason they do is there's so much money involved in it these days. But on the education side, I also have to say, and having worked in technology my whole career, I think that there's another aspect of technology that we need to really start paying closer attention to. And that is, I believe a lot of the technological developments going on today are raising the possibility of new existential threats. We started a nuclear age in 1945. For 40 years, the fossil fuel industry has been well aware of climate change being caused by their efforts. And today we have on the horizon many more such existential threats, most of which have absolutely no regulation of any kind. And I'll just tick off a few. Drones, cyber warfare, artificial intelligence, robotics, genetic modification, you name it. These are all potential threats for which, oh, and I should also mention big tech and social media. They play a very important role because both of those, and particularly corporate media, have influenced the direction of IP law in ways that have really created a lot of problems in our economy and made
Irv, do you have a specific question you can share with us so we can continue on?
Oh, question? Well, yeah. Well, the question is, what should we do, if anything, about trying to regulate these various kinds of technologies that may be creating new existential threats?
All right. I think, I think that the technology issue, of course, is something that's broader than the session now. So maybe we'll come back to that in a little bit, if that's okay.
Sure.
Dave, what is your experience with trying to get business people or more diverse groups of people to understand intellectual property from a business perspective.
Well, yeah, coming back to your question, I do agree with Bruce that it's easier to get IP professionals to pay attention to business than the other way around. What I find is the business people typically are, and even the general attorneys, frankly, are very quick when they see an IP issue to dump it on the IP people and wash their hands of it. And I see that, I've seen that through my whole career. You identify something as an IP issue and everyone will shunt it right off to the IP lawyers and forget all about it. And that's really unfortunate because, I find myself frequently saying that IP strategy is frankly too business critical to be delegated to IP people. It needs to be handled by the board.
Someone with your stature to make that statement and get away with it. I think that's.
It needs to be handled at a board level. So, IP education of business people as one of the many diverse audiences that need to see IP education very, very critical.
And I think, what about boards? What do you think about boards of companies? I always got the sense that board people were put on for many various reasons, and they have such a critical role, but they know very little about IP in general. And that if they did, then they might ask questions, which would then force the situation in companies to improve. Is that
I think that's generally the case. The board has almost never brought in members for their IP acumen. There are some exceptions, companies that are, very much heavily based around intellectual property, but by and large, that's right. Now, the way that changes is when some board level decisions wind up depending more directly on intellectual property. Like if, we now have a situation where somewhere around 80% of corporate value is in intangibles, but they're very frequently carried on a company's balance sheet simply as, goodwill. And when accounting principles and standards change, and that goodwill line is required to be unpacked and defended and explained, and particularly when, like in acquisitions and divestitures, when frankly, the destruction of huge amounts of value is required to be accounted for and explained, then you'll see boards become more concerned across the board, if you will, about intellectual property issues.
I know that Anne-Charlotte has had her hand up for a while. Would you like to ask a question or a comment?
No, I just, hello, Bowman. It's very nice seeing you although you were so far away. We're here at the dinner table. But I think this is a very interesting issue because it's a double-edged sword when we speak about Europe and Sweden, because IP people, whether it's easy to educate them or not, IP people, they tend to always think and talk about the classic IP, patents, trademarks, copyrights, and so on. Except a few, because there are a few that are a bit more open-minded. And they are the ones meeting the business. So that's what they're talking about as well. And then the business, they don't see the other assets that they have, but you have so many other IP assets in a business. So if we sort of have a catch-22. And I would say that the education or the master at the CIP, like the one that you were talking about, is very good, because that's where you open up the eyes much more and say you have so many more IP assets in the businesses than you could imagine, than what you learned when you were studying the law. And I'm trying to advocate, for those who don't know me, I'm a litigator in Sweden at an IP boutique firm, but I also teach at the CIP here in Sweden, and it's so fun. It's so fun also when you mix. I was talking to one of the judges of the Patent and Market Court today, and I said I'm teaching at the master course, and it's so fun because you have such a mixed audience, and I think that is the way of getting the message through, that there is so much more. We cannot just focus on, but you still have some work to do about that, and we who are working with IP and have a more open mind have more to do about it. But so I'm not sure you could say it's easier to teach the IP people, it's easier to teach the business, because it's a catch-22. We have to sort of stop that one and interfere with it. Thank you.
Thanks. No, I think when you have the students, they're young, they don't necessarily know that what they're being taught is something that lawyers should only learn or one person should only learn. When you get older, you kind of get moved into places, and as Dave said, you hand things over to one another to do. You kind of division of labor, and that's the tricky part. And that's why we catch them earlier then. So Jelani, what's the strategy here from the Michelson Foundation to teach people early about IP? How do you measure, how do you know what to teach them? I know this is something Bruce is interested in as well. And how do you know whether it's going to make an impact? How would we know? How can we measure this and try to keep improving on it?
Right. So from our perspective, something we've really focused in on is IP as a part of the entrepreneurship curriculum. So for the first couple of years of the initiative, that was truly the focus, making the case that IP should be a part of that curriculum. And we all know there's been just tremendous growth across institutions, across whether it's undergraduate, whether it's K-12, postgraduate. We see a tremendous rise in entrepreneurship education and very little IP integrated therein. So that's been a focus for us, showing students that, of course, they want to learn about the business model canvas and design thinking and all of these things. But they, in the midst of their programs, we see a big makerspace movement. We see more inventorship programs. These students are creating tremendous value early, and are they learning how to capture that value and anything about the fundamentals of IP or strategy? So entrepreneurship is a big focus for us. And I think that, maybe as you alluded to, some of the challenges is more so in teacher professional development. And a lot of the educators in this space are really uncomfortable teaching IP topics, which I find interesting because many of these educators aren't entrepreneurs, though they teach entrepreneurship. But when it comes to IP, they sort of have a discomfort around, the legal topic or the strategic topic of IP. So how can we develop perhaps more educator professional development and resources that they feel that they can kind of fill this gap that we see, and be able to teach to students even the fundamentals before they can move on and learn that more in depth from other sources. But that's one of the challenges I think we see in our space, in the undergraduate space, community colleges, and high school as well.
Now, it's interesting because we want people to know about IP, and we think that's the bottleneck. But then we need the people to know enough to teach it to people. That's the bottleneck. Right. We have a similar thing when we created our program. We created this almost like new professional, and then we had to say, okay, well, who's going to hire them? And so then we had to work with the companies to say, okay, you need people in these positions. So it requires some more work than it looks like from the beginning, that's for sure. But I'm glad you're working on it. Bruce, I know you have some take on what people should learn. What's good enough to learn? What should we be teaching?
Yeah, yes. Yeah, well, that's a very good point, Bo, because, as professionals, and we've, CIPU has had a number of conferences, and we attend yours and other conferences, and we wring our hands and we agree that IP is misunderstood, it's undervalued, it's disrespected, but we don't agree on what are the most basic things, most basic facts that need to be understood about IP. What are 3 or 4 principles about IP that are kind of universal that you could probably teach a 12-year-old or even younger, and certainly a business student should know that. We don't agree on that. And what CIPU has attempted to do with IP ABC, IP Awareness Basic Central, kind of a website within our website, is put a stake in the ground. We have 6 principles that we believe, this is the consensus of our research, are important. Now, there could be 16 principles and there could be 4 principles. Probably better to keep them fewer. But we as professionals need to agree at least that people, business people, educators, STEM educators, students, consumers need to know these few things. And maybe that'll differ by group, but we don't agree on that. And that's terrible, because if we can't agree on what's important, what are the 3 or 4 most important things, they're not going to agree. They're too confused. We have to direct them. And as Jelani points out very appropriately, we need to educate educators. We're trying, CIP is trying to get on the radar of the National Media Literacy Teachers Association. It's called National NAMLI. 7,500 members. It's hard to believe, hard for me to believe there are 7,500. A lot of them are STEM teachers, some are not. It's all about media and digital literacy. And just the fact that IP is on that radar, they're never going to teach it, or not in our lifetime, perhaps. But they're aware that IP is a part of digital literacy. And if we can accomplish that, that's a lot. So that's what we're thinking about. And I implore IP professionals to kind of pare it down. What are the basics? Not just the definitions of what is a patent and what is a trademark. That's sort of legal, and that's important. I mean, it has to be accurate, but at the same time, what do we need to leave people with? And there's this incredible hostility towards IP, which, as Judge Michel points out, is created, somewhat consciously, somewhat subconsciously over many years. And we need to battle against that. People need to be a little more sympathetic towards intellectual property.
Let me follow up on this a little bit. Ian Harvey, I see your hand up. Hold on just a second. I see I'm gonna just want to follow up on this because Judge Michel brought it out. He talked a little bit about the political economy of, I always get excited by the political economy of things, about intellectual property issues. And of course, one thing we've done for a long time in CIP is that we never taught IP as IP itself. We always taught IP strategy. It was always in the context of business. Is it possible, as Judge, you said there's a lot of rulings that are bad, we don't want to teach people that. Is it useful to teach people the IP system as if the way it's written, how it actually works, when it really doesn't work like that, that there's a lot of problems? Is it possible to teach IP without teaching people the practical, strategic way that IP will be managed in the market if you go there? What do you say, Judge Michel?
Well, you used the phrase political economy, and my experience working inside the Federal Circuit for 22 years was that few, if any, colleagues had any meaningful grasp of the political economy of innovation, investment, invention, and related realities out in the real world. They tended to treat patent policy as an aspect of precedence, which meant that they looked at words written by earlier judges in allegedly comparable cases. So in effect, they were treating innovation economics or the political economy of invention as if it were a philosophical or almost religious discipline where you looked at some underlying text and tried to divine how to decide the case at hand based on some vague implication from some phrase in some prior case. So among the audiences that need to be taught, informed, educated about the IP as it operates in the business world, the laboratory world, the science world, and so forth, judges and law clerks very much have to be one of the many important target audiences. And there's actually a fair amount of resistance on the part of many judges, including on the Federal Circuit, to being educated about those matters because they're suspicious that they're being importuned by some special business interest or industry or technology. So, for example, I worked very hard to get a former venture capital big shot from Silicon Valley to become part of the program at the Federal Circuit's Bar Association's annual conference held every June. And there was actually a lot of resistance to that Similarly, some interesting programs were put on by a number of organizations in Washington, basically down the street from the Federal Circuit, including by the Innovation Alliance, and also the Sedona Conference and other educational entities interested in IP. And all the judges were invited, and the chief judge was given an award at one of these conferences. Quite a handful of Federal Circuit judges showed up for the lunch hour when the chief judge was getting the award, and then they all immediately left. So they didn't hear any of the insights of the many investment experts, patent law experts, business experts, and other panelists. So they missed the whole point of being invited to the conference out of their suspicion or their anxiety about being, lobbied in some ex parte sort of fashion. So judges are resistant, but they need to know the realities of invention and investment more than practically anybody. And the same sort of thing could be said about members of Congress and key staffers of those members. They mostly don't have any sense that they need to know or ought to know anything about the economics or about the legal aspects because they aren't convinced it's relevant. And if you try to educate them, sometimes there's intellectual resistance because they've been told 1,000 times that patents are usually bad, usually invalid, cause more trouble than they help, and so forth. So there's a lot of resistance on the part of that audience too. But as Bo emphasizes, it all ties together in the real world. It is business, it is law, it is technology, it is innovation, it is investment. It's all these things, and they are interrelated. And if we can't get across how critically and usefully interrelated they are, I think no matter what else we accomplish, it won't move the needle.
Dave, what do you say? Is it worthwhile to teach people IP, kind of like the vanilla IP, without telling them what they're about to enter into in the marketplace?
Well, I think it depends, Bo. I think it depends on who. So, if you're talking
maybe not
about
kindergarten people, we can leave them out of it.
Okay, for the moment, okay, that was where I was going to go. If you're talking about professionals, then I think a context is needed. Yeah. People don't want to just study something for the most part just out of curiosity. They want to study it for a reason. Particularly technical folks like engineering students or even engineers in practice, scientists, researchers. If they're studying or learning about intellectual property for a reason and they understand the reason, it's going to catch their attention much better. And it's going to be contextualized much more effectively for them.
I think so. I mean, we always complain that the system, and of course it goes up and down, but if the system is operating under a certain legal regime where it's more difficult, it doesn't do any good to teach people that you get a patent and everything's good. You have to teach them the reality of the situation.
Right.
So,
yeah, much more complex and nuanced. Yeah.
Ian, you had your hand up. Sorry for making you wait. Ian Harvey, please.
Hi, Bo. I'd really like to continue down this theme of education and thinking about education across the span of the age groups. Because you have the adult side, you have university, you have high school, and so on. I went to Harvard Business School, and I tried to get Harvard later to teach something about IP as part of strategy. And there was no interest at all. They didn't know. They said, well, if people want to understand about IP, they can go and audit Law 101 on the other side of the river. Those of you who know me know that I've spent some time working in China, and for 10 years, having failed to get business schools in the rest of the world interested in IP, got a very quick uptake from Tsinghua in Beijing. where I've been teaching a course, running a course on IP, innovation, and corporate strategy for 8 or 9 years. Now, that led me into seeing what China does in the area of IP and trying to stay clear of the political and geopolitical issues. China, I think as many people know, have actually built a very good legal IP system. China has had IP at the center of its 5-year plans for the last 30 years. And part of that has been the legal system. Another part has been education. Education at the university level, the high school level, and the primary school level. For example, I've got here the textbooks for the 7-year-olds on trademarks and designs. I've got here the textbooks, comic books for the 7-year-olds on patents. And you can see here on the inside pages the kind of things which they're doing. Interestingly, having just skimmed through this over the past 5 minutes or so, over half of the participants, people shown here, are girls rather than boys. But the result is that kids of 9 or 10 understand about IP, and they think that using someone else's IP is like stealing their mind. They've really built it in at a very early stage. And the people that I met at Tsinghua who'd been through this kind of process didn't need any teaching. They understood that IP was fundamental to the utilization of innovation. Now, I think that anything like 5-year plans in the rest of the world is probably hoping far too much. But just thinking about Alan Lowe's discussion earlier, who are the influencers on social media talking about IP? How can we harness what social media does, the good side of social media? How can we create some influencers so that they can influence the young people to become interested and start asking the questions so they know they don't know?
Yeah. So Demi, when you were, before you took our course, what was your thoughts? What did you think about intellectual property? Had you heard about it at all? Did you have any, what was your interaction with it at all?
I just, when I thought of IP, I thought of, patent lawyers, and I just thought about law in general, and just thought, like, it's a lot of reading, a lot of writing, don't want to get into that. And like, as an engineer, I have more of a creative side in my mind. So I was like, I don't want to be, learning about how to write and read patents. So that was my outtake on IP in general before I came to Berkeley and before I took this capstone. So what Ian was talking about with, what kids are learning in China is really incredible, even like down to 9 and 10 years old reading books like this. Something like that would just be crazy in America. Like, no one's going to buy their kid a book about patents to read about just for fun. So, but stuff like that, little things like that actually go a long way. And we don't even realize that. But yeah, I feel like if we could start, and I know, like, of course, kids are not our main focus. As Paul was saying earlier, talking about congressmen and things like that, they're the ones we want to target right now, just to get our government talking about IP in general. But I feel like if we start with the next generation and get them interested, when the older folks are kind of moving their way out and the younger ones are coming in, they will be focused more on IP and things like that. So yeah, for me, I didn't know much until I started talking to you and Matt and Lee in this past year, but it's definitely been an eye-opener for me. And I think it should definitely be continued to be taught to people my age group and younger.
And how is it to work now that you haven't taken like a full law degree and gone into everything in detail,
Yeah.
but you work with a lot of IP people nowadays, are you?
Yes,
Is
yeah.
there space for people that know IP in a broad sense to get into the business? Because that's always been a problem, I think.
Yeah, no, there definitely is a space for me. Like I said, my background is just engineering, and I'm just an intern at RPX currently. So I don't have a law degree, and I'm still learning as I go. But everybody I work with at RPX are, very much well-read in this space, and they're more than willing to teach me, things I need to learn along the way. and just to teach me about IP and the whole world about it. And it's been a great experience so far. And I think that if people are more willing to be open to learn about it, it's not scary. It is complex and there is a lot, and I still have a lot to learn, but it is something that, you know, you can get through. And I think people, at least the people I've worked with so far, have been more than welcoming, more than, you know, kind enough to teach me what they know.
Thanks a lot, Demi. Going back to Ian's more kind of fundamental approach, which I think is probably easier to do in China in some ways than it is in the West. But this idea that people at a younger age are more willing to accept certain ideas, to be more open to ideas. But then I link a little bit back again to what Paul was saying, because once you get to a certain level, whether you're in Congress or you work for a company, or maybe you're on the Supreme Court, you definitely have a set of ideologies that will block you. I mean, I think that Paul and I talked about this, that like ideology is like self-inflicted ignorance. You've decided that there's other evidence out there, but you're just not open for business. So once people get ideological about certain things such as intellectual property, or of course, if you're interested, you might have studied for a long time about the importance of IP, but then you go work for a firm that doesn't necessarily think that it's that important, then it's going to be tricky. So how do we overcome, for the panel, if we go through and talk, how do we overcome the fact that intellectual property has this very fundamental usefulness for the country, but it's not so obvious to talk about that usefulness without a relatively in-depth conversation, and that every little thing that can be made negative about IP so easily fits on a hat? How do we overcome that? How is that possible? Would you like to kick us off, Dave? I give you the tough question.
Yeah, no, it is a tough question, and it's something I spend a lot of time, you know, puzzling over, because there is such a tremendous misunderstanding. People are focused on getting today's thing at the lowest price. They're not at all focused on, you know, on what's next and the new products and services that you would want in the future and won't get but for incentives for people to go out and create them. That alone doesn't fit on a hat. So it's not a conversation you can have, you know, at a casual level. But as a result, I've come to the conclusion that the best way to have the hat level conversation is to appeal to innovators, whether they're people who write music, people who perform music, people who write stories, people who play musical instruments, people who make films, innovators, inventors, people who create new things, and talk to them about the desirability for them of having control over what it is they create. That in concept does fit on a hat, and that's the kind of thing that and I've managed to challenge even small children with the notion that look, you created this stick figure drawing, you know, or this one-line poem to your mom or dad. It's yours. Why, you know, don't you want other people to respect it? Even little kids quickly will agree with that. And so that's the best I've been able to come up with.
You know, Dave, it's Bruce here. I think sometimes that trademark and content, copyright and trademark, brand/trademark, are kind of the tail that wags the dog with patent. Consumers can relate to that. They can relate to plagiarism. They can relate to counterfeits and piracy. They have a feeling that that's wrong. The patent discussion can follow sometimes. It's not the same thing, I realize, but there are similarities. But it's interesting to me that both tech, or certain areas of tech, IT, perhaps big tech, if you want to call it that, and consumers have a similar hostility to IP, and it feeds off of one another. It's in the interest of a lot of large technology companies to have people hostile towards IP and towards content. And so they are hostile, and they're hostile for their own reasons, and they're also hostile to help and indirectly it helps those large companies. It's something that needs to be considered. I'm not sure what can be done about it.
Yeah, I was going to suggest a little history on this. You know, the term intellectual property only came into being around 1980 when we finally got people in Congress to understand that intellectual property was about jobs in their districts. So currently, the Licensing Executive Society Silicon Valley chapter, of which I'm a board member, is exploring the notion of intellectual capital management as a broader umbrella for intellectual property, which is, you know, one of the components of intellectual capital management. And I also want to come back to Bo's comment about we need to have board level people on companies that have an interest in intellectual capital management or IP, whatever you want to call it, because you need the people at that level to focus and get other people pulled into that discussion. So just a thought about maybe moving in that direction.
Thanks. So Jelani, how have you seen the difference in the students at in your level in your programs? Have you seen a big change in how people think, and can we scale this up in a meaningful way?
Well, I think to follow up on what we've talked about before, Bo, and also what many of the other panelists and guests have mentioned is around sort of this branding problem with IP, and maybe it's time to bring in a new set of IP heroes. The students that we see today, you know, when they hear about IP, they think Coca-Cola, McDonald's, Nike, these big corporations. That has nothing to do with me. But for example, a course that we co-developed at University of Southern California, they hear IP strategy from new companies that's really exciting to them. So Dollar Shave Club, for example, how did they become a unicorn valued at over $1 billion in just a few years, and they have no assets? So sort of these new stories, these new kind of IP heroes, the branding aspect of it. I love the idea of the influencers, which Ian mentioned, and ushering, I think, some fresh air into the stuffiness of the IP concept, which a lot of students, that's how they feel about IP today. Or they feel, well, we're so collaborative, we just want to be collaborative, and IP is going to stifle us. So we've seen with some surveying that we've done, less than 10% of students understand about IP, but at least 30% know a lot about Creative Commons, actually. So what are they doing, you know, that organization, and how they're speaking about these topics and making it compelling for today's students and young folks. So that branding aspect, I'm really interested in, actually.
That's good. That'll be fun to work on that. I think we need like a new, you know, used to think I grew up, you know, I'm old now, you know, Edison and people like that. And now we need new people and how this relates. And that's great. Judge Michel, I'm going to give you the last word. We're running out of time. But is there any hope from an ideological and interest perspective? There's lots of lobbyists, as you mentioned, with judges and Congress persons and people on that level. Is there hope that we can
I think
them to understand
well,
our message?
I think there's a lot of hope at every level, and the reasons are really twofold. Aggravated by the current pandemic was the underlying economic problem that American society needs to create an enormous number of new jobs in order for ordinary people to be able to make a living and support their families and have a half-decent life. And there are many forces decreasing the availability of jobs. Obviously, offshoring of manufacturing is one. Automation is another. Loss of global competitiveness is another, and so forth. So I think that as soon as it becomes somewhat clearer to people at various levels, from the local level right up to the Congress, that job creation depends critically, not only, but critically, on a well-functioning innovation system and the protections of IP that foster that innovation system, the tide will begin to change. And then the second thing, beyond the necessity of very rapid, massive new job creation, the other problem I think that might finally get the attention of influencers and decision makers and policy makers is the threat of Chinese economic and technological and possibly even military domination of the whole globe if the U.S. doesn't revive its ecosystem.
Good. When I asked that question, I was hoping you were going to give us hope. That would have been a bad ending otherwise. For the, but there are jobs, and national security tend to get people motivated, and hopefully we can get them to understand the relationship with intellectual property. Well, we've finished our time for today, and I would really like to thank the panelists. So thanks to Bruce and Jelani, and to Dave and to Demi and to Paul, who's helped to chair this session and helped to build it with me. I think everyone should come off of mute now and give a bit of applause for everyone so we can feel a little connected. Thanks, everybody. Have a good,
Thank you, Bo.
evening wherever you are.
Thanks, everybody. Thanks, Bo.